I'm very happy to be here in this conference on insolvency and bankruptcy code organized by the CAFRAL. And this is a post-lunch session, so I understand you would have had a very good lunch. So I seek your attention. I wish to congratulate CAFRAL also for taking this initiative and would like to thank them for inviting me to this event. Originally, I was scheduled to be here yesterday, but due to some other exigencies, I had to change the schedule, and I am here today. And let me also mention that, it's on a personal plane, it's a matter of great delight and opportunity for me to again be talking on insolvency and bankruptcy code in a public forum after quite a while. I distinctly remember that when I was Secretary Economic Affairs, this draft legislation we prepared. It was going on and on for quite some time. Then we put together a small team led by Mr. Vishwanathan, TK Vishwanathan, not NS Vishwanathan, but TK Vishwanathan, who was formerly, in the Ministry of Law and also in the Parliamentary Affairs, and it was chaired by him, and we put together a small team to prepare the draft legislation. The RBI obviously was represented in that group. And when we made the first presentation to the Prime Minister and explained to him that the wide-ranging impact that such a legislation will create, and impressed upon, explained that this is a really big reform. His only question was that then why has it not been done so long, so far? And his instructions were very clear that please have it expedited. Mr. Arun Jaitley, who was also present, who was the finance minister that time, who was also present during the presentation, he said, yes, we will take it forward. And looking back, I think in my experience, this is one piece of legislation which was drafted, placed in the Parliament, referred to the Joint Select Committee of both Houses of Parliament. The Joint Select Committee went into the legislation clause by clause. They had a clause by clause reading with wide participation, of members of Parliament from various political parties. Report of the Joint Select Committee submitted to the Parliament. Government considered the recommendations of the Joint Select Committee. Decisions were taken. The bill was taken up for consideration, passed by the Parliament and notified. So this entire process, I think this was in history so far, in my recollectable memory, I think this is one of the fastest pieces of legislation which was enacted and which was put into actual implementation. And a lot of credit goes obviously to the entire team in Economic Affairs Ministry Department, in RBI and other stakeholders who were also participating in ensuring this. In particular, and I am aware that I think the contribution of Mr. Arun Jaitley to forge a consensus and taking everyone on board and then answering each and every point in the Parliament, that was really exemplary. And so here we have the legislation. Of course, it has evolved over a period of last, since 2016 it was passed, and so it has evolved, and there have been very good outcomes of it. There are several learnings from our experiences, and there have been several challenges. So broadly, I propose to highlight some of them today. Now, internationally, bankruptcy laws, as you are aware, serve a larger public cause of providing an avenue for recycling of capital tied up in inefficient firms and realigning the deployment of this capital deployment of this capital in other productive purposes. The bankruptcy laws promote entrepreneurship in the economy. They also provide means of distressed borrowers to negotiate, or rather renegotiate, their debt with the creditors, and the creditors to exercise their rights over borrowers in the event of default. In the Indian context, as you would be aware, our credit markets are dominated by the banks. The stressed debt held by the banks is usually an outcome of anticipated as well as unanticipated risks that have manifested. Willful default or frauds are, however, a separate category. At a systemic level, a high level of stressed debt is generally caused by excessive leverage, poor underwriting, lax post-disbursement surveillance, and other exogenous shocks that may emerge from the real economy. Recent economic history has shown how the above factors have contributed to high level of stressed debt in various geographies. Even in the Indian context, we had witnessed a huge pile-up of stressed assets about a decade ago. High level of stressed debt generates major adverse consequences in the credit system by way of misutilization of capital, averseness to lending, and crowding out of investments. Seen from this perspective, the enactment of the Insolvency and Bankruptcy Code (IBC) has been a landmark reform in the economic history of India. Prior to IBC, the laws in India had brought the legislative, executive, and judicial arms of the Constitution to dealing with distressed firms in isolated manners. In this background, the Bankruptcy Law Reforms Committee, which I was referring to earlier, chaired by Sri T.K. Vishwanathan, this committee had strongly opined that the appropriate resolution of a defaulting firm is a business decision and only the creditors should make it. As a culmination of this thinking, the IBC as we have it today lays substantial emphasis on resolution mechanisms driven by the creditors who have been empowered to initiate insolvency proceedings against a defaulting debtor. Such a process facilitates greater transparency as well as accountability. The Reserve Bank, being the regulator of a large part of the credit ecosystem, has been a key stakeholder in the implementation of the IBC. The RBI has taken several measures dovetailed into the IBC with a focus to resolve large value stressed accounts. The RBI was conferred with an explicit role in leveraging the IBC as the primary tool for resolution of large legacy stressed assets. The amendments to the Banking Regulation Act carried out in 2017 inserted a clause that authorized the Reserve Bank to issue directions to any bank to initiate corporate insolvency resolution process in respect of a default under the provisions of the IBC. Accordingly, leveraging these powers, the Reserve Bank issued directions for initiations of these resolution proceedings in 41 specific cases of default. The other significant implication of IBC from a regulatory perspective was a shift towards a more principle-based approach as far as out-of-court resolution is concerned. All existing schemes of restructuring of loans were substituted by the Reserve Bank by way of, through a simple and harmonized framework for resolution under the prudential framework which was issued by the Reserve Bank on June 7th, 2019. You would recall that the February 12 circular, which earlier had attracted a lot of attention in the media and among the financial sector players, among the borrowers, that was struck down by the Supreme Court. And after that, we worked on this entire resolution framework and we came out with this framework on June 7, 2019. The harmonized framework provided discretion to the lenders for designing and implementing resolution plans in respect of borrowers in default, subject to evaluation of commercial viability. The resolution plans could also include filing of resolution applications under the IBC In respect of large value borrowers, that is where aggregate exposure of banks were in excess of 1,500 crore, disincentives have been prescribed by the Reserve Bank in the form of additional provisions to be made for delayed implementation of resolution plans. Several of these accounts have since been resolved under the IBC. Let's now do a stock taking of the implementation of the IBC. If we have to take stock of the implementation journey of the IBC and its impact so far, there are significant positive indications as well as learnings suggesting the need for some course correction. Let me first highlight the positive aspects in terms of the positive aspects, meaning in terms of the outcomes. And I would like to mention 2 points here. One, the nature of resolution. 3 points. One, with regard to the nature of resolution. 2, realization of value. And 3, behavioral shift. In terms of nature of resolution, since its inception, 7,058 corporate debtors have been admitted into the resolution process, of which 5,057 cases have been closed. That is, out of 7,058, 5,057 cases have been closed, and in 2001 corporate debtors are in various stages of resolution. Of the cases which have been closed through resolution, around 16% have yielded successful resolution plans. 19% have been withdrawn under section 12A of the IBC, where largely the debtors agreed for full or partial settlement with the creditors. 21% were closed on appeal or review, and 44% of cases, liquidation orders have been passed. Putting together the 16% cases which had successful resolution plans and the 19% of cases where the corporate debtors agreed for settlement, it can be said, that is 19 plus 16, it can be said that 35% of the total resolution cases which were put to resolution, saw positive impact of IBC. A fine combing of the data would indicate that 77% of the cases which ended in liquidation were inherited from the earlier BIFR regime, or where already defunct units were, or they were related to defunct units where substantial value erosion had taken place before their admission under the IBC. So it was quite natural that there was nothing left, no value left, and they had to go on down the liquidation road. In fact, the code has provided all these legacy cases a means for an early exit. To illustrate further, 38% of the resolutions which yielded a successful resolution were earlier with BIFR and were defunct. And if not for IBC, their fate would have perhaps remained uncertain even till now. The data published by the IBBI suggests that there have been an increase in the number of resolution plans resulting in resolution as a percentage of liquidation orders, going up from 28% during FY 17-18 to 45% during 22-23. So cases, have really gone up during this period, which have been sort of resulted in a resolution. This reflects a steady tilting towards resolution option under the IBC and highlights the increased acceptance of IBC as an appropriate statutory umbrella for turning around viable firms. Even in other segments of the financial sector, entities such as non-banking financial companies, that is NBFCs, even in respect of the NBFCs, the IBC has provided an effective enabler for resolution of stressed assets. I am referring here to section 227 of the code, which was operationalized through a separate notification issued by the government for resolution of certain financial service providers, and this notification, you would recall, was issued in 2019. The Reserve Bank has been able to leverage this mechanism to undertake resolution of a few stressed NBFCs in the recent past with minimal disruption to the financial system. So I said that, I would like to comment on the outcome of the IBC from three different parameters. The first I said was from the point of view of the nature of, in terms of the nature of resolution. The second point is in terms of realization of value. Creditors have realized rupees 3.16 lakh crore out of the admitted claims of rupees 9.92 lakh crore as of September 23, which works out to a recovery rate of 32%. It needs to be emphasized here that significant value destruction would have already happened in these assets prior to their admission under the IBC. Further, a comparison of realized value with admitted claims may not be a reasonable indicator of the effectiveness of the resolution process. Rather, the resolution value may be compared with the liquidation value of stressed assets or their fair value at the time of admission to the IBC. When evaluated from the prism of these two parameters, namely the liquidation value and the fair value, the realization rates are 169% and 86% respectively, which appears quite encouraging. Let me say that, this copy of the speech will be uploaded in the Reserve Bank website, so all these numbers are available. So if you want to make a reference to that, it will be available. The third angle from which we have to measure or we have to assess the outcome of the IBC is in terms of behavioral shift. The most interesting outcome of IBC has been the substantial behavioral shift ushered in by this code. This is evident from the 26,500 applications for initiations of resolution process having total underlying default of rupees 9.33 lakh crore which were withdrawn before admission. And this is the figure till August 2023. The credible threat of insolvency ignited by the code has strengthened the negotiating powers of the creditors, in the absence of which it is more likely that those defaults would have lingered for much longer, resulting in value destruction. It has to be stated here that the IBC would not have seen, should not be seen as merely a loan recovery instrument. It has to be seen as an instrument which facilitates preservation of economic value of assets through effective resolution or unlocking of capital which is stuck in unviable businesses. Now let me turn to the challenges and the way forward. If all is good about the implementation of the code, then where is the criticism coming from? In general, the criticisms of the IBC are on two fronts. First, the time taken for resolution, and second, the extent of haircuts vis-a-vis the admitted claims. I have already shared my perspectives on the haircut part. Let me now share some thoughts on the delay part. The code envisages a time-bound process requiring completion of the resolution process within 180 days with a one-time extension by up to 90 days in exceptional circumstances. The data published by the IBBI, however, raises certain serious concerns. As of September 2023, 67% of the ongoing resolution cases had already crossed the total timeline of 270 days, including the possible extension period of 90 days. More concerning is the fact that the average time taken for admission of cases during financial year 2021 and financial year 2022, that is 21-22, these two financial years, FY21 and FY22, stood at 468 days and 650 days respectively. Such long degree of delays will substantially erode the value of the assets. There are multitude of factors playing out here, namely the evolving jurisprudence related to the code, litigatory tactics adopted by some corporate debtors, lack of effective coordination among the creditors, bottlenecks in the judicial infrastructure, and similar other factors. I wish to touch upon some of these issues along with thoughts on possible way forward, and I would like to make four specific points here. First relates to realigning the dynamics between creditors and corporate debtors. The IBC transfers full control of the corporate debtors to the creditors during the period of resolution through the resolution professional. The rationale for the same is to prevent any erosion of value during the process of resolution. Given the loss of saddle, we see that promoters of the debtors in many cases resorting to various litigatory tactics. While there could be bona fide reasons in some cases, other kind of intent are also visible in the market. To minimize this friction, there has been an institutional attempt towards adopting the pre-pack schemes, which is essentially a debtor in possession model. Globally, pre-packs have evolved organically without statutory interventions because in those countries, the insolvency regimes had stabilized. In such predictable scenarios, the judiciary's role gets minimized and it's rather limited because the courts generally approve the resolution plans after verifying compliance with the laid down tenets. In the Indian context, to start with, the pre-packed insolvency resolution process has been rolled out for the MSMEs. The response towards this adoption, however, seems to be relatively muted. One reason could be the hesitancy on the part of the financial creditors in approving the proposals under this mechanism wherein the haircut is perceived as voluntary. It may be stressed here that this pre-packaged process will incentivize the promoters, that is the promoters of the promoters of the debtor companies to constructively engage with the creditors, possibly even before occurrence of any default event. This would facilitate swift and smoother resolutions, avoiding unnecessary adversarial litigation. Overall, this could be a win-win situation for both creditors and debtors. Once this perception is established, there could be a greater acceptance of this mechanism for larger corporate debtors as well, as and when the statutory enablers are in place. Thus, in their own interest, the creditors and debtors may consider adopting this pre-packaged system in applicable scenarios based on prudentially realistic cost-benefit evaluations. From the Reserve Bank side, we are cognizant of the limitations of out-of-court resolution framework, in particular the coordination issues, since a large part of the creditor universe like mutual funds, insurance companies and other bond or debenture holders, they are outside the scope of the Reserve Bank's prudential framework for resolution of stressed assets. Hence, we have a special interest in effectively dovetailing the out-of-court workouts conceived under the prudential framework with that under the prudential framework of the RBI with that of the IBC. This resolution, pre-package scheme could be a potential game changer in this regard. The second point I would like to highlight, I said 4 points. The first point I have made. The second point relates to reaffirming the financial creditor's role. Through the course of last 7 years of implementation of the code, the jurisprudence on the role of committee of creditors has evolved. The COC has a fiduciary responsibility to safeguard the interests of all stakeholders. The success of the code is linked to an active involvement of the committee of creditors in driving the resolution process forward. On several occasions, however, the adjudicating authorities have raised concerns regarding the conduct of the COAC, so the Committee of Creditors, in the insolvency proceedings. This includes lack of participation in the meetings of the Committee of Creditors, lack of engagement or effective coordination among the creditors, disproportionate prioritization of individual interest of creditors rather than their collective interest while designing the resolution plans, which can be detrimental, and this approach can be detrimental to the resolution plan itself. Given these shortcomings on the part of the Committee of Creditors, there appears to be a trend in recent years towards balancing the rights of operational creditors with those of the financial creditors under the code. While the focus on ensuring equity among all stakeholders may be appreciated, there needs to be some distinction in weightage attributed to different category of creditors depending upon the degree of risk absorbed ab initio. It has to be recognized that the financial creditors take the maximum risk and hence their risk needs to be commensurately compensated and compensated with priority. Accordingly, any amendments to the code and its evolution thereof may continue to lay emphasis on financial creditor-led resolution framework in an overarching manner. The third point I want to highlight is with regard to envisaging a group insolvency mechanism. While the insolvency mechanism has been graduating towards a zone of stability through various concerted measures, one visible impediment seems to be the absence of a clear framework for group insolvency. Globally, there are two diverse facets of group insolvency. Some jurisdictions have adopted either procedural coordination or substantive consolidation. Substantive consolidation pertains to consolidation of assets, liabilities, and operations of multiple entities within a group, disregarding their separate legal entity status. On the other hand, under procedural coordination, the approach is limited to aligning procedural aspects like filing requirements, timelines, coordination, etc., and not mingling of the entities or not, combining all their assets and taking them for resolution together. In the Indian context, in the absence of a specified framework, the group insolvency mechanism has been so far evolving under the guidance of the courts. Perhaps the time has come for laying down appropriate principles in this regard through legislative changes. There has been quite a bit of brainstorming on this issue in policy circles for some time now. The task now is to move forward through appropriate legal changes. While a legal framework cannot envisage all plausible real-world scenarios, given the complicated group structures at the ground level, including cross-border linkages, it may be in the fitness of things to formally conceive a framework to start with. There would be challenges in this journey like intermingling of assets, devising a definition of the term group, addressing cross-border aspects and similar other factors. It would still be preferable to see this as an opportunity and put in place a workable framework for group insolvency. The fourth and the final point I would like to mention is with regard to developing a vibrant secondary market for stressed assets. One major impediment for implementing a successful resolution plan has been the absence of a vibrant market for stressed assets in the country. This effectively limits the pool of prospective resolution applicants for stressed assets under the IBC. In fact, this applies to even our regulated, that is the Reserve Bank's regulated entities, when they transfer their stressed assets outside the IBC process. A robust secondary market in loans can be an important mechanism for management of credit exposures by the lending institutions. It is in pursuit of this objective that certain measures have been taken by the Reserve Bank. The master directions on transfer of loan exposures issued in September 2021 lay down a comprehensive regulatory framework for transfer of loan exposures by banks, NBFCs and all India financial institutions. In particular, an enabling framework has been put in place for transfer of stressed loan exposures to a wider set of market participants subject to specified specified conditions. We are also currently in the process of formulating a framework for securitization of stressed assets, for which a discussion paper has been issued in January 23. The comments have come, they have been examined, and we are now on our way to issuing the, the revised framework for, transfer of, that is securitization of, that is for securitization of stressed assets. From an institutional perspective, the Reserve Bank has brought together a core group of major banks to set up a self-regulatory body, that is a secondary loan market association. The self-regulatory body is expected to play an important role in standardization of documentation and market practices, setting up the market infrastructure, promoting liquidity, efficiency and growth of the secondary market in alignment with broad regulatory objectives. These measures are expected to facilitate transfer of credit risk originating in the banking sector and ensure market-based credit products for diversified set of investors. Undoubtedly, the germination of an active secondary market ecosystem will have consequential benefits for the IBC mechanism. Let me now conclude. Apart from what I have highlighted, there are several other aspects which merit attention. These would include leveraging technology to optimize the disposal of cases, strengthening the judicial infrastructure, regular stakeholder awareness programs, and the like. From the Reserve Bank's side, we have also been consistently engaging with the stakeholders to understand their thought process on the emerging challenges to arrive at likely solutions. The recent steady improvement in asset quality of the banking sector can be attributed to a multitude of factors, including the introduction of the IBC. Now, the Indian banking sector has really, this is one sector which has really seen a remarkable turnaround in recent years. If you contrast the situation which prevailed 10 years ago with all those high, gross NPA, the asset quality review resulting in the, the GNPA levels touching an all-time high, because as a consequence of the asset quality review, the figures which were there in 2018, from that we have moved to a situation where the GNPA, NNPA, and all other, in terms of other parameters, I think the banking sector had truly shown a remarkable turnaround. Now, talking specifically about IBC, let me say that a law is only as good as its implementation. The Reserve Bank would continue to have focused interest in the orderly and sustained evolution of the IBC ecosystem. Now I would like to stop here. Thank you all for hearing me with so much patience. Thank you. Namaskar.